the organizers and our session hosts who did that lovely introduction. I'm Beety, and I have a PowerPoint to share, which I hope will make this a bit more interesting than just watching me speak. And I really would love to hear your thoughts in this area, your questions. So I've opened up a little Twitter feed. So if you go to my Twitter, which is at Beety, so it's the same spelling that you see underneath my name here, Beety. So if you go to that, you'll see a little tweet that I just posted that anyone who wants to join our convo or ask questions, please respond here. And I'm going to right now, happy to get started with all of you. So anyone who wants to send in a question, please do. That would be a possible way for us to be able to talk a bit through this medium. And with that, I will share my PowerPoint. All right. So again, I'm so happy to be here. And part of what is bringing me here to talk with you today is a book that I published in June called Manifesting Justice, Wrongly Convicted Women Reclaim Their Rights. And in this book, I tell my own story, and I also tell the story of women who have been wrongfully convicted, and in particular, two of my clients who are queer women who were wrongfully convicted. So about myself, I am currently a law professor at Arizona State University. So that's the slogan on the side. I also am one of the leaders in our criminal justice center there, the Academy for Justice. But before I came to Arizona State, I was in West Virginia, and I founded and led the West Virginia Innocence Project. So Innocence Projects investigate if people are wrongfully convicted, and if they find the evidence to show that the defendant is innocent of the crime for which they were convicted, then they bring that evidence to court, trying their best to reverse these convictions. And that is very hard. It's very hard to reverse a conviction after it has been deemed final. And our criminal legal system really does focus on finality rather than looking at all of the evidence. But that's the work that I've done, and I continue to do. I continue to be an innocence litigator. And that's one of my clients on when he was released, and that's him holding the photo of him when he first went to prison. So I wrote the book Manifesting Justice to tell stories, particularly from the queer community, from our community. I recently became aware of the fact that the term queer is not necessarily adopted outside of the LGBTQ community. So I do want to say I identify as queer. I do not see it as a derogatory term. I think many people within the LGBTQ community embrace it. But I did want to put that out because I've inadvertently shocked some people by by using that term. But it is a frequently embraced term within the LGBTQ community. So my own story is that I was a rape victim advocate for a number of years, and that's what led me to go to law school. I felt that through being an advocate, I was helping one person at a time and one survivor at a time. And I thought that through being a lawyer and through being a prosecutor, I could stop cycles of violence. Many sexual assailants are repeat offenders. So I thought that by convicting an offender and sending them to prison, that would stop cycles of violence. And I learned, and I got my dream job. I was able to become a federal prosecutor, and I prosecuted domestic violence and sexual violence crimes. So I got my dream job, but I learned through the process of that our system doesn't necessarily look out for survivors, doesn't necessarily do what's in the best interest of survivors, and really will sacrifice survivors in order to obtain that conviction that we believe in so much. And those convictions are frequently far less severe than we would expect. So I had a number of charges that I would drop down from a felony to a misdemeanor because we thought it would be more likely to get a misdemeanor conviction. So then we're talking about people going to prison for an offense for less than a year. And prison itself is what's called criminogenic, which means it actually increases the likelihood of people committing crimes when they're released. So it doesn't stop certain behaviors, and it doesn't stop what I thought it would. I thought that prison would stop these cycles of violence, but it doesn't. Unless, again, we're able to incarcerate someone for a long time, and most of the time we're not able to do that. So I really started to look at other alternatives and other solutions, and I looked more at restorative justice. And I also then switched careers, and I became an innocence litigator. So I started representing people who were wrongfully convicted. And I started doing that work in Mississippi. So I moved from Washington, D.C. to Mississippi to do innocence work. So I became an innocence litigator. I moved away from thinking incarceration could be the end-all solution, and started litigating these cases. And I started representing queer women. So I'm a woman married to another woman. I identify as a queer woman. And I saw that not many women generally were represented in innocence work and post-conviction work. So I appreciated the opportunity to be able to do that work. So the story in the book is really about Lee Stubbs and Tammy Vance, who you see here. There's a happy ending. This is them on the day of their release from prison after a decade in prison. But their story began in 2000 when Lee and Tammy met at a drug rehabilitation center, and they fell in love. And they graduated from that program. So they were leaving the program, and they took a new friend of theirs who they had also met there, Kim. They took that friend along with them. Kim had asked for a ride to her boyfriend's home. So they took Kim with them, dropped her off at the boyfriend's house, but they stayed there about an hour and they were leaving, and Kim said, no, I want to come with you. So Kim came with them, and Kim had taken her boyfriend's Oxycontin pills. So sadly, within less than 48 hours of being released from this program, Kim has taken this Oxycontin in combination with alcohol, and she overdoses. So very tragic. She overdoses. Lee and Tammy call 911 for help, and the ambulance comes and takes Kim to the hospital, and Kim's in a coma. And while she's in the coma, there's a doctor who examines her and believes that he finds some indicators of like a sexually aggressive encounter. So like pedal marks on her butt, and then some redness in her vaginal area. So the doctor tells the police, and the police bring in someone who has now become infamous, a dentist. They bring in Dr. Michael West, who is a dentist from Hattiesburg, Mississippi. Might sound surprising, but Dr. West is also what's called a forensic odontologist, which means that he's a bite mark expert. So he comes into the hospital, he examines Kim's body while Kim is unconscious, and examines Kim completely naked. completely naked, which is horrifying to me. And he claims that he finds bite marks. Now, there's never any other evidence of bite marks, and no one else finds bite marks, but he claims that he does. And those bite marks, alleged bite marks, then start the ball rolling towards assault charges against Lee and Tammy, who were the two women who were with her immediately beforehand and who were lesbians. So that started the ball rolling for their wrongful convictions. So how were Lee and Tammy wrongly convicted? It was a combination of bogus bite mark evidence. And at the end of this presentation, I'll go through a couple of examples of bite marks and the unreliability of bite mark evidence is not reliable. And then homophobic testimony against the two of them. But I want to share a history we have in the United States of criminalizing queerness. So criminalizing LGBTQ plus expression and identity. We have a full history of this. And there's a lot of text on these slides, but I hope it's not too much. So there are what's called in this wonderful book called Queer Injustice, there's what's called kind of these queer criminal archetypes. So these stereotypes about homosexuality, about gender nonconformity, that influence police behavior, that influence punishing people who are queer or not acceptably gendered. So it's these narratives of danger, of deception, of disease, depravity, violence, all of these kinds of nonconformity, negative stereotypes that are then attached to queer people and that influence them at every step along the way in the criminal process. So in their arrest, in charges brought against them, and in the trials they have, or what plea offers are given to them. So this history goes back quite a long way, but we can see particularly this was at its height in the 1950s after the Lavender Scare, where we saw psychiatrists who would label LGBTQ people as mentally ill, that it was a mental illness. And there was, in particular, a strong fictional bond between being a lesbian and having a mental illness. Again, a fictional connection, but that narrative was used to prosecute queer women in particular and to support their convictions. So we have this history of, again, being LGBTQ deemed as a mental illness. So it really, when we talk about overcoming shame, it was hugely important that in the early 1960s, LGBTQ people started to speak out and to say, no, we don't have mental illnesses. Yes, we exist. And we work right alongside you. We are your family members. We do not have a mental illness. This does not mean that we are mentally ill because of our sexual orientation and gender presentation. So the gay rights movement in the 1950s really started to, again, push back. And here's one example of one of the early protests where, again, they're also specifically dressing in a certain way to try to convey that they, again, do not have mental illness, that there are queer people everywhere in every walk of life. But in the 1950s, every single state criminalized sodomy in some form. Now, sodomy actually means oral sex or anal sex. So that doesn't specifically mean between two people of the same gender, but the only people who were charged under sodomy laws were LGBTQ individuals. So although these laws apparently applied to all people in a number of states, some states it was specifically just against same gender sexual activities. But that's what they were used for. So a targeting there. And if you appeared queer, so if you, for example, you didn't wear 3 items of clothing that matched what was supposed to be your gender, that could also be a violation. If you were dressed in drag, that could be a violation. That was seen as, and when I say violation, I mean like a criminal charge, that was seen as deceit. So these sumptuary laws were laws against cross-dressing or disguising yourself, and those go back to 1845. And then we see, again, groups like the Madison Society and the Daughters of Bilitis that were arguing that being queer was not criminal, and it was also not a mental illness. I'm going to pull up my Twitter just to see if there's any questions that have been posted. And I, again, would love to see any questions from anyone who is interested and is following. All right. So I'm going to keep that up so we have it. So the gay rights movement in the 1960s and 70s really pushed back and led to some tremendous change. So we see the protest at Compton's cafeteria riot in San Francisco in 1966. So that was before Stonewall. And that was by trans individuals, by drag queens, protesting in 1966, and then the Stonewall riots in New York City in 1969. And those really provoked states to decriminalize sodomy and to eliminate these sumptuary laws by saying, here we are, we exist, these laws are unjust. These laws lead to wrongful convictions. And there was a joint effort between gay and Black communities against police profiling. And finally, in 1973, homosexuality was dropped from the DSM. So it's no longer labeled as a mental illness. In the 1980s, there was a move forward and a move back. So the Supreme Court upheld Georgia's anti-sodomy law in Bowers versus Hardwick in 1986. So this is at the same time as the AIDS crisis. So as the AIDS crisis is beginning, the AIDS health crisis, which particularly affected gay men, there was a refusal by the presidency, by President Reagan, to address it, to even say the word AIDS for years. And a refusal to really provide funding that could lead to finding a cure, a vaccination, a treatment of some sort. So there was this tragic, horrible epidemic that killed so many people. And at the same time, the Supreme Court says, no, you can still criminalize queer people based on their sexual behavior. So, quote, to hold that the act of homosexual sodomy is somehow protected as a fundamental right would be to cast aside millennia of moral teaching. So that was one of the points from the opinion. In 1987, in response to this, queer activists organized to create ACT UP, AIDS Coalition to Unleash Power. And that was really, again, to not be shamed and to speak up and dispel these myths about AIDS and dispel myths about queer people. There were so many myths, particularly about gay men at that time and about the transmission of AIDS. So this was crucially important. Organizers led die-ins and proclaimed, as you see in the signs, that silence equals death. And it was a successful effort on their part. So in the 1990s, we did see greater funding for AIDS research. And so we did ultimately have scientists discover a reliable treatment for AIDS. And now, I mean, nowadays we have PrEP where if you're taking PrEP, your viral load can be so low that you can't even transmit it. Which I don't know if everyone knows that when you're on PrEP, your viral load, like I said, can be so low that you no longer can transmit it, which is huge. But that said, in 1996, Congress also passed the Defense of Marriage Act, preventing gay marriage specifically, affirmatively. So this was everything that was kind of happening in the lead up to Lee and Tammy's wrongful conviction in 2000. And then I want to talk about another wrongful conviction, which is the San Antonio Four. So the San Antonio Four were 4 women, 3 of them Latina, all lesbians, who were convicted based on kind of satanic abuse charges. So at the same time in the 80s and 90s, there's this satanic panic scare that caretakers and daycare providers are doing crazy things to little kids, like taking them out in a boat to watch, babies be thrown off to be fed by sharks, or watching the teacher, drink the blood of a newborn. I mean, just it was through coercive interviewing of these children that you get these fantastical stories, but these fantastical stories then led to very real charges, particularly against women and against queer people. So the San Antonio Four are an example of 4 women who were convicted for a crime that never occurred. So it was an alleged sexual assault against these 2 girls who were the niece of one of them, and it never occurred. And it turned out that they, again, were coerced into making these charges by their uncle, who himself had made sexual overtures to this woman, and she had rejected him. And frankly, when they came out and said this didn't actually happen, the uncle tried to sue one of the women for custody of her children, and fortunately failed, but shows the violent and vindictive nature of that individual. So I encourage you to look more into the San Antonio Four. There's a powerful documentary called Southeast of Salem about their case as well. So that's kind of the background. There was a Lambda Legal Survey survey in 2012, and they're doing another survey right now. So it's 2022. They're doing a 10-year survey. It's open until the end of July. This is Lambda Legal and in coordination with Black and Pink. And they want to hear from LGBTQ individuals, people who identify as LGBTQ, about their experiences in the criminal legal system. So I highly encourage folks to fill out that survey so that we can just have more informative results about the experience of queer people in the criminal legal system. So this is results from 2012. Ethan Rice at Lambda Legal passed these on to me. So the question was about whether individuals received negative comments about their sexual orientation, their gender identity, or their gender expression. And out of the people who said yes, 28% of them were low income, 30% were people of color, 33% were transgender nonconforming, 53% were transgender nonconforming people of color, and 66% were trans women of all races and ethnicities. So we see a particular bias against trans individuals and trans women. 50% of people who identified as lesbian and gay heard jokes in the courtroom. 38% felt threatened in the courtroom and felt like either they couldn't be open about their identity or were forced to be open when it wasn't related to their case. There's also jury trial studies, so from mock juries in the 2000s, showing that 45% thought homosexuality was not an acceptable lifestyle. So these are all things that are coming into the courtroom against a defendant who is LGBTQ. So that leads us to this question of passing. It's so important for us to be visible right now when there's so many narratives against queer people, gay people, trans people, that visibility is really important. But for the individual in the courtroom, they are likely more harmed by showing their queer identity than by passing. So it's a very personal question about how people represent themselves in a courtroom. For myself, I would frequently dress in a very conformative, gender conformative way when I, particularly when I was in Mississippi representing clients. I talk about this in my book because I didn't want any hostility against me to be transferred to my clients. And I wanted the judges to hear what I was saying. But we don't change the culture of the courtroom when there's passing. We don't change our broader culture when we pass. So there's a real trade-off here, a very big trade-off here. And it's a personal decision in the courtroom. But that said, also, you could be outed as well for it to be used against you. So there's just a lot to consider there. So next I wanted to talk about character assassination. I'm going to add another thing here. I'm saying I'm talking about passing and character assassination in the courtroom for queer people. So I hope, again, that's Valina Beety, at Valina Beety on Twitter. So I'd be happy to hear from any of you on Twitter if you have some questions about this. And it's Valina Beety, VALENA BEETY. BEETY. Okay. So let's talk about the evidence that's used in the courtroom that exploits these biases against queer people. So first, I'll give the example of Darnell Wilson. And these are examples I also share in my book, Manifesting Justice. So Darnell Wilson received a life sentence for stealing bras from Kohl's in Mississippi. It was Darnell's third offense. And so Darnell got a life sentence literally for stealing bras. And Darnell identifies in many ways, but as gay, as trans, as a drag queen, and presented as their authentic self in the courtroom and took the stand. So here is the testimony from Darnell. So the prosecutor says to Darnell, is looking at this video. Says, so you've got in your hand here on this video a purple and beige bra, right? This is in front of a jury. Because Darnell goes to trial. Darnell challenges this. I'm sure it was a bra. It looks like one. Was that for you? Prosecutor asks. Okay, completely not relevant. Should have been objected to, shouldn't have come in at all. Completely irrelevant. I have one and I will wear one again. So Wilson, takes this in stride and is very proud of their identity and shares that. But their attorney should have objected to this whole line of questioning because it was just used to stoke any bias. You wear bras? Says the prosecutor. Yes, I do, of course. So you're saying you dress, I'm sorry to even say this out loud, but so you're saying you dress up like are you a man or a woman? Wilson, a female impersonated, transsexual, transgender, homosexual, all of that, and excellent at what I do. Prosecutor. And again, none of this should have come in. Prosecutor, may I ask you a question, Mr. Wilson? When that's not how Wilson was presenting on the stand. You may. still doing the prostitution thing. Again, completely not related at all, conflating sexual orientation and gender identity with sex work. And again, just inflammatory for the jury. So Wilson is found guilty and sentenced to life in prison, where they are still in prison in a men's facility in Mississippi. So part of the point of my book is that wrongful convictions are more than claims of factual innocence. So one example I give, but Wilson's case is another example where even if they did steal the bra, they shouldn't get a life sentence for it. I see that as a wrongful conviction. So it's not just about factual innocence, it's about whether this conviction is just, whether this conviction should be upheld, as well as the sentence for it. And in the book, I give an example from No More Deaths, No Más Muertes, which is an organization down along the border between Arizona and Mexico, outside of Tucson, where members were leaving water, jugs of water, in the desert for migrants who were passing through. For years, they were able to do this, but under the Trump administration, this led to criminal charges against these individuals for leaving water in the desert. So this humanitarian act becomes a criminal charge of polluting, trespassing on federal property because they left them in parks. And again, they left them specifically where there were trails of where migrants would pass through. And this is life-saving water. And yet they had these charges and they were initially found guilty. And then their convictions were reversed. But that's another example of a wrongful conviction that is more than just a claim of factual innocence. Manifest injustice, the claim in my book, isn't just about factually innocent people, it's about unjust convictions as well. So let's return to Tammy and Lee and how they were wrongfully convicted with evidence in the courtroom, faulty forensics, and homophobia. So let me give you some of the testimony in their case. So this is the expert testimony. So an expert is supposed to be someone who's reliable, has expertise. So this was the dentist, Dr. Michael West, who was testifying. So question, so in a homosexual rape case, you would expect to find bite marks. It would not be unusual at all to find bite marks on the skin. And West says, no, it wouldn't be unusual. In fact, it would be almost expected. Almost. So here's your prosecution expert. And he continues to go on to claim that part of the overdose survivor's genitals have been bitten off, which he called usually a combative or a sexual orientation phenomenon. So again, there was no other evidence that her genitals had been, her labia had been bitten off, except for Dr. West saying this. No other evidence. There wasn't blood, like nothing to indicate that that's what had happened. But it contributes to this story against the two lesbians who are being charged, contributes to this narrative. So unfortunately, the defense expert for Lee and Tammy also testifies about bite marks and LGBTQ individuals. So question, would you expect to find biting, or would biting be consistent with a lesbian rape type situation? Yes, the defense expert says, homosexual crimes are very sadistic. The more violent crimes I've seen in my experience are homosexual to homosexual. They do what we call overkill. They do tremendous damage. They're more gory. The more repulsive crimes I've ever seen were homosexual to homosexual. So this is the defense expert's testimony. So then the prosecutor in closing says the bite marks are important because they indicate a homosexual assault. And obviously put on testimony, I shouldn't say obviously, but put on testimony of people who saw Lee and Tammy kissing and that they felt uncomfortable with seeing them kissing. But set them up as lesbians, and lesbians are likely to bite people, and we have a bite mark here. Kim was alone with these two lesbians. It leads you to think there's no other answer to this than that these two women bit her, which none of it ever happened. So would their cases be different today? So lawyers can act to exclude character assassination evidence. If it's a relevant fact, like if sexual orientation does need to be known, that can be what's called stipulated, where both parties agree to this fact. It doesn't need to be asked on the stand, like, oh, do you identify as a man or a woman? Like, doesn't need to be asked on the stand. It's just being used to stoke bias. So if it is relevant, which who knows whether it would be, but if it is relevant, it can be agreed to as an agreed fact. And I want to also point out intersectional biases. So race also intersects with gender identity and discrimination. So does disability. Disability intersects with gender identity discrimination. And this is one chart about harassment by police. But as I was saying earlier, is at every stage. It's at being stopped by police for loitering, right? For walking while trans, for not having an appropriate identification on you, and then an arrest, and then prosecutors bringing charges. Prosecutors have complete discretion about whether they bring charges or not. They never have to bring charges. And we see that in certain cases that are never prosecuted. It's also at the stage of where prosecutors bring the charges and then what pleas are offered. I'll also just point out here that there's a horrible trend, epidemic of trans individuals and particularly trans women being murdered in our country, particularly trans women of color. And those are murders that aren't solved, that police aren't necessarily putting the time in to solve. So on the one hand, queer people are over-policed and are more likely to be arrested for loitering, for waving to passing cars. And yet when something serious happens, it's far less likely to be investigated. So that leads me to where we're at in our country right now and with narratives in our country right now. And I'm just looking back at this in case anyone has questions. And I'm not seeing any, but please remember you can send me questions on Twitter. So there are narratives sweeping our country right now that are very emotional narratives. So many people in the criminal justice area over the past 10, 20 years have really tried to collect data on, are prisons beneficial? Who is criminalized? Who is prosecuted? Why are people prosecuted? Why are only some people prosecuted for offenses? Like I was saying about, decades ago with sodomy laws, why are only LGBTQ people prosecuted for sodomy under anti-sodomy laws when the law itself is against, oral sex between straight people as well? So, who is actually targeted with arrests and with prosecutions? And there's been such an effort to collect data, and yet in the past year, there's been this sweep of emotional narratives against queer people. So in Texas, with not providing healthcare to trans kids, and that if you're a parent who has a trans kid and you're trying to provide this healthcare, that you could have your child taken away from you. You could be charged with child neglect. And that's, again, that's harmful narratives against trans children, trans individuals, but also their family members. And then we see in Florida, a recent bill to make it a crime to bring a child to see a drag performer. And I just wanted to share this video. I don't know how many people remember this from just a couple years ago. And let me make sure the sound is on so you can hear it. Share sound. And all right. So I just wanted to share that because it shows that we can change these narratives. So right now there's this narrative of taking a child to see a drag queen would be harmful and should be criminal if parents do that. But we see here like this beautiful moment from just a couple of years ago where there's this really touching interaction between a drag queen and a child. And we have far, far more examples of how many drag queens do reading hours at their local libraries for children, and just these positive interactions. So it's these, again, these negative criminal tropes of danger, depravity, deviance that are connected to queerness that are being mined to support these actions and to support these bills. And it's, again, it's emotional. It's not based on data and not based on information that we know. And we see these stereotypes also extending to, again, calling gay men groomers, that they're grooming children, which these are, these were stereotypes that were prevalent in the 80s. And they're coming back again and again. They're emotional. And I think it's important for all of us who are LGBTQ to be vocal about our identities, to share our identities, and make clear that being queer does not mean that we are dangerous or deviant or harmful. And these laws are, again, based on emotions. And are so dangerous. But we can take back the narratives and we can change the narratives. So I just want to conclude. And again, I'd love to see if anyone has any questions, but I'd love to conclude with just a little information about bite marks themselves. So Lee and Tammy were wrongfully convicted because of biased testimony about them being lesbians and about lesbians being violent and lesbians biting people, but also because of bite marks, which are completely unreliable. And even within the now discredited field of forensic odontology with dentists, they themselves would agree that there's a tremendous lack of reliability to bite marks. So I'm going to show you actual bite marks. So these are actual photos of bite marks. They're not, speculative. Is it a bite mark? Is it not? Because that is itself its own problem. These are actual bite marks provided by Dr. Mike Bowers. And I want you to be able to see the range of what bite marks can look like. So a lot of these are on children. So it's children biting other children. That's where we tend to see a number of bite marks. So here's one example. Here's this child, and you can see two bite marks here. They look like they can be bite marks. No, sure, those could be bite marks. But how would you match those bite marks to a specific dental mold to say who was the biter? Here's another version of bite marks. These look less like bite marks, more splotchy. And again, in a criminal case, the prosecutor is saying, here's the dental mold of the defendant, and we've had an expert match the dental mold to the bite mark. So what dental mold would match this bite mark or these series of bite marks, especially when you can't even really tell where one bite mark ends or the other begins. So that's another example. Here's, again, another example of bite marks. So these are more like red, blurry. Here's one on the face. So it's a big red circle. There is some dental impression there, but it's largely a big red circle. And then here's one that looks pretty clearly like a bite mark at this point. And you can see the outline. But then the question becomes again, so whose dental mold matches to that bite mark? Here on the left are 3 different dental molds. So 3 different dental impressions, 3 different people. So first of all, can you see differences between those 3? And it shows how similar our teeth can be. But each of those are different. They're all 3 different people. So again, what's kind of the similarities and differences between them themselves? And then which one matches the bite mark? So which of those on the left matches the bite mark? And the answer is whichever dental mold you want to match the bite mark. So if your suspect is the red outlined dental mold, then that's going to be who matches likely. So just a visual example of the unreliability of bite mark evidence. And that this evidence comes into court. So here's an example of bite mark evidence that came into court as a bite mark with these, that's supposed to be the bite mark, or these little spots on the skin. So I just wanted to share that information. So thank you very much. This is my information. If you're interested in the book Manifesting Justice, I hope you'll check it out. Ask your local library to carry it, or your local bookstore. I'm Valina Beety. I am at Arizona State University. This is my email address, and that's also my Twitter handle. It's also my Instagram handle. And it's been wonderful talking with all of you. I'm going to stop the share. And I'm just going to check my phone one more time to see if there's any questions that folks may have. And if you want to take this moment to send a little question, I'm going to say we're wrapping up. And I don't see any questions. I hope this has been informative. I think it's particularly important right now, as again, we're looking at these laws to not only criminalize certain acts by trans individuals, but also the next thing down the pike is to roll back gay marriage so that states don't have to provide gay marriage. And after that could be rolling back sexual relationships. So we could see anti-sodomy laws come back again. So criminalizing sexual behavior and sexual expression again. So all of that could happen from the recent Dobbs decision. And like I said, we're seeing laws being passed around the country right now, particularly about transgender individuals. So thank you for your time. And I don't see any questions. So it was great talking with all of you. And that is it. So session hosts, I'm gonna turn it back over to you and can happily close this out.
This concludes the 6 o'clock session of Track 1, Shame No More, Sharing Wrongful Conviction Stories